Hello everybody, welcome. It's a beautiful morning today here in Great Neck, and I just wanted to share this great information with you as I take my dog on this beautiful walk. Alright, so today's morning discussion is, when you bring a medical malpractice case and now you are at trial, during opening arguments, after I have had a chance to go ahead and make my opening arguments, and now the defense attorney is given an opportunity to make his opening arguments, can the defense lawyer ask the judge to throw out your case before he ever has a chance to go ahead and actually make his opening arguments? Would you like to learn the answer? Come join me on this quick walk as I share with you the answer to that question. Hi everybody, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, yes, he can. The defense lawyer, before he has a chance to get up and go ahead and make his opening arguments to the jury, can actually ask the judge to throw your case out. Now you might be wondering, I don't understand. It's been years to get your case to trial, right? So here's the scenario. You believe that your doctor was careless, and you believe that his carelessness caused you harm and injury. And now what do? You brought a lawsuit against your doctor claiming that number one, he was careless, number two, that his carelessness caused you harm, and number three, that your injuries are significant or permanent. All right, what happens then? What happens then is that the doctor answers those allegations. And what does he say? He says, why the hell are you suing me? I did nothing wrong. Second, he says, you know what? If I did something wrong, so did you, Mr. Patient. You caused or contributed to your own injuries. Can you imagine that? Then he says, if I did something wrong, whatever I did not cause or contribute to your injuries. And then he says, okay, if I did something wrong, and that wrongdoing caused you harm, guess what? Your injuries really are not as bad as you claim them to be. So what does that mean? It means that now the doctor's basically saying, hey, I'll see you at trial. Now, in New York, that means it'll take anywhere from 2 to 3 years for your case to come up for trial, because we have the entire discovery phase of the litigation process that can take up to 2 years or 3 years even. So what happens then? Well, let's say we go through that entire litigation process, and now it's 2 years after you started your lawsuit. Your case finally is coming up for trial. Now, it's been months. You're anxiously waiting for your case to come up for trial. Your attorney calls you one day and says, listen, the judge has selected a date for jury selection, which means now that we are going to go into trial on this particular date. Hang on one second. Daisy, come on. Let's go, baby. Come. We're going for a walk. All right. So now we're at trial. The judge turns to me after giving the jury preliminary instructions and says, Mr. Oginski, you may begin your opening argument. Now I get up to give my opening argument. And after a period of time, I now sit down, and then the judge turns to the defense lawyer. And what does he say? He says, defense attorney, you may now begin your opening arguments. And now the defense lawyer gets up out of his chair, and before he even begins to say a single word about his opening arguments and what he feels the defense is in this case, he turns to the judge and says, Your Honor, at this time I ask that you dismiss Mr. Oginski's client's case. And now you're wondering, what did I just hear? How is that possible? How could this defense lawyer, before he even went ahead and made opening arguments, how could he be asking the judge to go ahead and dismiss your case? I'll tell you how. You see, in New York, when we are required... Let's try that again. In New York, when we go ahead with opening arguments, we, as the patient's attorney, as the plaintiff's attorney, we are required to go ahead and lay out what's called a prima facie case. Now, what does that mean? It means we have to establish a number of things in our opening argument. So what are those things that we have to establish? Well, we have to establish, number one, that there's liability, number two, that there is causation, and number three, that there are damages. All right, so what does that really mean? It means I have to show and explain to the jury why we're here. What is it that we're claiming the doctor did wrong? What wrongdoing did the doctor do to cause or contribute to your injuries? That's what we have to show. And we have to show that the proof is going to show that there was wrongdoing, that the wrongdoing caused injury, and that the injury is significant or permanent. All of those things have to be laid out by the attorney who represents the injured patient in order to establish what we call a prima facie case. If we don't establish each one of those elements, now the defense lawyer would be well within his right to turn around and say to the judge, Judge, Mr. Oginski didn't lay out all of the things necessary, all of the elements necessary to prove his case. He only showed that the doctor did something wrong. And if that's all I showed, then you know what? The case deserves to get dismissed. If I only turn around and said, listen, this doctor was wrong, this doctor violated the basic standards of medical care, causing this patient harm. Well, guess what? Now I laid out only 2 of the necessary 3 elements to establish that we have a valid basis for a case. So what happens then? Well, the judge will have to consider whether or not I've laid out a valid case in order to go forward. So what happens after that? The judge has to decide whether or not I have, in my opening arguments, laid out a prima facie case, established liability, or shown that we are going to prove that we are slightly more likely right than wrong, that what we are claiming is true, that the doctor was careless, that his carelessness caused you harm, and that the injury is significant and or permanent. All of those things have to be established. But the defense attorney, you'll notice, is going to do everything possible, multiple times, to try and get your case dismissed. So just because we get to trial, don't think for a second, don't even think for a second, that the defense lawyer is simply going to roll over and address your case on the issues, on the merits, because in fact he's not. Instead, he's going to do everything possible, use every possible legal device to make sure your case never gets in front of the jury. And if he is lucky enough to have the judge say, you're absolutely right, counselor, now there's the possibility that your case will be dismissed before ever getting to the jury. And you're thinking, I don't understand. I waited all this time to get to trial. Now let's put all the proof and all the evidence and all the testimony in front of the jury. Let them make a decision. Well, what will happen? If the judge agrees with you and your attorney, then you'll be able to do that. But if, during the course of your trial, the judge says, hey, wait a second, your attorney and you did not do A, B, and C, and because of that, you never even get to the jury, I'll tell you what, your case is likely going to get dismissed. And I'll share with you another scenario in which that might happen. So let's say opening arguments are done. Now both sides have made opening arguments. All right, so what happens after that? What happens after that is that after you put on all of your proof, all of the testimony and all the witnesses that you need in order to support your claim that you are more likely right than wrong, now what happens? Now, after your attorney tells the judge, Your Honor, at this time, the plaintiff rests. Now, it doesn't mean you stop and take a breath, or that your attorney stops and take a breath before going up a hill. It simply means that you have finished putting on all of the proof necessary in order to get a verdict. That's what it means. All right, so then the trial judge will turn to the defense attorney and say, Counselor, all right, now it is your turn to put on whatever evidence you feel is necessary to mount a proper defense. And if the defense has no witnesses or they want to try and get your case dismissed, what will the defense attorney do? He will turn to the judge and say, Your Honor, at this time, I ask the court to dismiss this case. And again, you're going to be in the same scenario, the same position, saying, wait a second, how could he possibly want to go ahead and dismiss my case? Let's just get this in front of the jury and get a verdict. Now the judge has to consider whether or not there is sufficient proof to go forward, whether there is sufficient proof for the jury to evaluate, and if the judge agrees with us, then yes, we will go forward. If the judge agrees with the defense lawyer, guess what? Then your case is over and finished. And now you'll have to deal with an appeal and figure out where to go from there. So why do I share this quick information with you? I share it with you because it's a beautiful day today here. While I'm walking the dog, I figured I'd share this terrific information. And you know what? I realize that you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but have not done so because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day, everybody.